22nd special meeting of the University of Minnesota Board of Regents. Chair Mayron is attending today's meeting remotely, so I'll be chairing in her place. Good morning. Like I said, I would like to thank everyone for joining us in the boardroom and by way of live stream. We have several regents joining us virtually today. Chair Mayron is joining us remotely. Vice Chair Kenyanya, Regent Johnson, Regent Bota Urabe, and Regent Farnsworth are joining us remotely at this point. And so the first thing we're going to do today is to begin, I will welcome Associate Vice President, Title IX Coordinator, Tina Marisam, and Senior Associate General Counsel, Carrie Ryan Gallia, to the presenters table for a brief overview of changes to the proposed amendments to the university's policies related to sex discrimination since we received them last. Introducing a new development that has risen since our last meeting. So given the recent preliminary injunction, the docket includes 2 resolutions for consideration. No, I'm going to stop there. I'm going to let you guys go on. We're going to continue later. Okay.
Thank you, Vice Chair Hipsch, members of the board, and President Cunningham. We are here this morning to present 2 alternative resolutions to the board. These resolutions approve several policies and rules that have been amended to ensure compliance with new Title IX regulations issued by the U.S. Department of Education in April. 3 Board of Regents policies are impacted: faculty tenure, sexual harassment, sexual assault, stalking and relationship violence, and the Student Conduct Code. 3 administrative policies are also affected: discrimination, sexual harassment, sexual assault, stalking and relationship violence, and conflict resolution for faculty, P&A, civil service, and student workers. And the civil service employment rules have also been amended. When we appeared before the board about 2 weeks ago to present these amendments for review, we debated whether to go into depth on the various legal challenges to the new regulations, given that Minnesota was not subject to either an injunction or pending litigation. Sitting here today, I'm glad that we did. We learned last week that the U.S. Departments of Education and Justice have been enjoined from enforcing the new regulations against almost 700 colleges and universities, including the University of Minnesota. Specifically, on July 2nd, the U.S. District Court for the District of Kansas issued a preliminary injunction barring enforcement of the regulations. The scope of the injunction reflects the plaintiffs who brought the litigation. The regulations cannot be enforced against schools in the 4 states that brought the case: Kansas, Alaska, Utah, and Wyoming. The case was also brought by the mother of a middle school student, and the injunction includes that middle school. And finally, the plaintiffs include 3 organizations: Young America's Foundation, Female Athletes Unite, and Moms for Liberty. The court included in the injunction schools attended by members or children of members of these organizations, as appropriate, and gave the groups until July 15th to notify the court of those schools. The July 15th notice includes the University of Minnesota. The government has already filed an appeal of the injunction to the U.S. Court of Appeals for the 10th Circuit. In addition, since our last presentation, a separate court enjoined the enforcement of the regulations in Texas, bringing the number of enjoined states to 15. And we continue to watch other cases, including a case filed by 6 states in the 8th Circuit, the federal circuit where we sit. That case seeks a broad injunction enjoining the implementation of the regulations. The Department of Education has been clear about its enforcement strategy. Where it is not enjoined from doing so, it will enforce the new regulations. And where an injunction is in place, it will enforce the current regulations, which were implemented in 2020. Our policies that are currently in place are compliant with those 2020 regulations. In light of the present injunction, the government's appeal, and the literally daily shifting legal landscape we're facing, we offer 2 resolutions for the board consideration. Option 1 approves the amended policies, but delegates the power to implement them to President Cunningham. This means our current policies will remain in place, but in the event the injunction is lifted, President Cunningham can direct the immediate implementation of the new policies to ensure our compliance with the 2024 regulations. Option 2 similarly approves the amended policies and contemplates that, in the event the injunction lifts, the board will promptly call a special meeting to direct the implementation of the amended policies. I will now hand the presentation to my colleague, Tina Marisam, who will discuss changes made to the policies since we presented them for review at the board's July 10th meeting.
Good morning, Vice Chair Hipsch, members of the board, President Cunningham. I will just briefly summarize the changes that have been made to the administrative policies on discrimination and sex discrimination since that July 10th meeting. First, we have now input into the policies the contact information for internal and external resources related to discrimination. Second, we've made 2 changes based on advice from the university's Policy Advisory Committee. The committee helpfully advised that we add to the policies that supervisors must communicate with the university's sponsored project administration about sex discrimination that may need to be reported to a grant funding agency, which we have done. The Policy Advisory Committee also suggested that we state with more specificity who is responsible for record keeping under these policies. So we have also added that it's the campus Title IX or Equal Opportunity Office, which is responsible for those record keeping requirements. This slide lists a few additional changes to the policy since the last meeting. After reviewing recent resolution agreements from the Federal Office for Civil Rights, we've made 2 clarifications to these policies to better align them with that office's statement about effective practices. First, we added a statement that Equal Opportunity and Title IX oversees the university's compliance with federal and state non-discrimination laws. And second, we added some detail around how the university can initiate a grievance process, even when there's not a participating complainant. And then finally, we added a statement that the revised policies apply to all reports of discrimination, except that we will apply the discrimination definition from the policy that was in place at the time the reported misconduct occurred. As for the final change since the July 10th meeting, we've also added an administrative procedure called sexual harassment, sexual assault, stalking, and relationship violence, reported to have occurred between August 15th, 2020 and July 31st, 2024. This procedure applies the 2020 regulatory requirements to sexual misconduct that's reported to have occurred during this time frame, as is required. Right now, the procedure is written with the assumption that the regulations take effect on August 1st. When implementing the procedure, we will need to ensure that it reflects the actual date that the regulations become effective at the university. As Carrie described, the implementation date for these policies remains unknown and will depend on future court rulings. Our plan is to continue making necessary preparations to implement these policies on August 1st or any time after, should the injunction be lifted. That is all the information about updates that we wanted to share. Thank you so much for being here to take up this resolution at a special meeting. We're happy to answer any questions.
Thank you both very much. As was said, given the recent preliminary injunction, the docket includes 2 resolutions for consideration. In both cases, the board would approve the proposed amendments. Option 1 then delegates to the president the authority to implement the new policies when it is legally permissible to do so, or option 2, on the other hand, would bring the matter back to the board at a future date to approve a resolution authorizing implementation. Since we have 2 options before us, I'd like to first turn to discussion, after which we would entertain a motion to approve one of the 2 options. So is there any discussion? Regent Johnson.
Thank you, Mr. Chairman. And thank you for your presentation. Can you give us the pros and cons of each option?
Absolutely. Thank you, Regent Johnson. They're very similar, the 2 options. I think the delegation to the president is sort of a faster option, a little bit more nimble, because theoretically, if this injunction is lifted after August 1st, which is the effective date of the regulations, we will be expected as of that date, when the injunction is lifted, to be compliant with those 2024 regulations. So a delegation to the president allows the president to make the determination that very day once we learn of the injunction being lifted. The option 2, where the board calls a special meeting, just takes a little more time. There's a couple of days there. I think it's not high risk if it takes us a couple of days to adjust to this sort of very shifting landscape. But that's really the only substantive difference, to my mind, is the timing of how the implementation would take place.
Do you have a recommendation?
My recommendation would be to go with option 1, just because of the nimbleness that gives us. And also, it's built into the resolution too, the recognition that there is a possibility, I don't like to think about it, that the injunction could be lifted and another court could step in 2 weeks later, 3 weeks later, and re-enjoin the regulations. So rather than calling multiple special board meetings and reconvening here to sort of implement or unimplement, the president can sort of direct that action a little quicker, I think.
Thank you.
Regent Kenyanya.
Yeah, can you hear me?
Yes.
Okay, thank you very much, Mr. Chair, Director Marison, and Councilor Rangalia. Appreciate y'all for the presentation. I'm certainly in favor for the first option. I think because we have the facts and we know what that policy is, it's just a matter of when. I think it absolutely makes sense to delegate that authority to the administration. I did have a question on the changes since the June 10th meeting, particularly on the one that the Campus Title IX office may appoint a designee to hold the process rights when there's not a participating complainant. I think I understand that one. I was hoping you could dig into it a little bit more, talk about what current practice has been and who those rights would be assigned to. Would that be the office, a staff member, or we can just talk a bit more about that change?
Thank you.
Okay.
Thank you, Vice Chair Hipsch.
Okay, thank you. So Regent Turner.
Thank you, Chair Hipsch. First of all, we had a question. Did they answer the question?
No.
Not yet.
No. So the
Oh, go ahead.
yeah.
If I wasn't clear, Vice
sorry.
Chair, that was a
I
question.
thought you were, okay, go ahead. I'm sorry, I thought there was a
Thank
question
you,
there.
Vice Chair Hipsch, Regent Kenyanya. Yes, good question. So there are cases where equal opportunity and Title IX in the university learn of concerns of discrimination, potentially serious concerns. But we don't have an impacted person, the complainant who's been harmed by the discrimination, come forward and say, yes, I want to participate in the investigation. And our grievance process is set up so that the complainant, the person who's harmed, typically has a bunch of rights in the process, in particular rights to review the evidence and also the right to appeal a decision that they feel was not substantiated or unfair. We as a university need to appropriately address those reports, regardless of whether the complainant wants to participate in an investigation, because we're responsible for ensuring a non-discriminatory environment. So different institutions have different ways of doing that. Some institutions will have, like, the campus Title IX office be the complainant. The way we have typically handled it is we move forward with the complaint. We can move forward without a complainant, but particularly if the concern is coming within a university department, so like an employment discrimination complaint, our practice has often been to ask the dean of the college to appoint someone from within that department, not to serve as the complainant, and not even to serve on behalf of the complainant, but to serve as a unit representative who has the process rights that a complainant would have, mostly because it's the unit's responsibility to ensure that non-discriminatory environment. So for example, if a case came through and there was a decision that that department did not feel was fair and would interfere with their ability to maintain a non-discriminatory environment, that they would have the right to appeal that decision. So that has been our typical practice, and we just now are writing, including it in the policy, in particular because the Office for Civil Rights has noted in some recent resolution agreements that that is an effective practice that they like to see in the policy.
Okay, thank you. Regent Kenyanya, did that answer your question?
Yeah, that was very helpful, Director Marison. And I guess that is saying what I thought it was saying. And I guess it stood out to me because it's important. This, regardless of the complainant's desire, we do have that obligation to uphold, the rights and have that. I imagine that could be tricky in terms of deciding who to assign those rights to, and people could raise all sorts of questions, conflicts, and whatnot. So I don't intend to take us down that rabbit hole. You've answered my question. Perhaps can continue the conversation offline. Thank you. I intend to support the first resolution. Thanks.
Thank you, Regent Kenyanya. Okay, Regent Turner.
All right, thank you, Chair Hipsch. First, just like question, when you say the university, we're talking all the campuses, right?
Yes.
Yeah, I mean, I don't know if why we're singled out. You said there's one school, so anyway, doesn't matter. But the other question I have is, you listed off everyone. I would assume that the groups here in the community that are under a union contract, that they still fall under and be able to use the Title IX procedures, right? For if they've got grievances, et cetera?
Go ahead.
Yes, thank you, Regent Turner. Absolutely. The Title IX protections apply to labor represented members. They have the same anti-discrimination and process rights that every other university community member has.
Right, and then I know that the grad students who are trying to create a new contract had some concerns, thinking maybe their grievance process would be faster, but they don't realize that both sides then would have to be, they would have to be defending the people that aren't even under their union, is the way that Doug Peterson said, kind of told me about. Is this being made clear to them? I mean, is there any other issue with the unions that are presently have contracts and the one that they are trying to get contracts? Is everyone kosher on this? Are you talking with them, or you're nodding your head? That's a good sign.
Thank you, Regent Turner. Yes, we have worked with our employee labor relations team in HR, and we have sent a letter to all of the unions that work with the university, sharing the change with them, and we have a meeting with one of them scheduled this afternoon to discuss it further. And we now need to discuss having a follow-up communication to share the information about the injunction with them, which we plan to do after the board meeting today.
Thank you. I appreciate that. Communication is everything. And I vote for the number one.
Sounds good. Regent Wheeler.
Yeah, I'll just say thank you to Associate Vice President Marison and Senior Associate General Counsel Galea. You've explained this well now over 2 meetings and gone with the shifting tide. So thank you. Thank you for that. And because of those shifting tides and injunctions coming and going, I would move forward with the resolution for option 1.
Thank you. Is there a second?
Second.
Okay. There's a motion and a second. Is there any discussion? If not, we'll proceed with a roll call vote, and we'll have Mr. Langworthy take the roll call.
On the motion to approve the resolution related to amendments to university policies related to sex discrimination, option 1, Regent Davenport.
Yes.
Regent Davenport votes yes. Regent Farnsworth.
Yes.
Regent Farnsworth votes yes. Regent Gully is absent. Regent Ruth Johnson.
Yes.
Regent Ruth Johnson votes yes. Regent Tad Johnson.
Yes.
Regent Tad Johnson votes yes. Regent Kenyanya.
Yes.
Regent Kenyanya votes yes. Regent Mayron.
Yes.
Regent Mayron votes yes. Regent Talurabe.
Yes.
Regent Talurabe votes yes. Regent Turner.
Yes.
Regent Turner votes yes. Regent Verhalen.
Yes.
Regent Verhalen votes yes. Regent Wheeler.
Yes.
Regent Wheeler votes yes. Vice Chair Hipsch.
Yes.
Vice Chair Hipsch votes yes.
The motion is approved. Great. Thank you. It's been a long run, so thank you very much. Okay. Our second item for action is on the recommendation of the East Cliff Property Task Force. As a reminder, this task force was charged with considering the retention or disposition of East Cliff in alignment with the guiding principles for the acquisition and disposition of property as defined by the Board of Regents policy, real estate and facilities. Since we reviewed the recommendation at our July meeting, there have been no changes to the recommendation. Given that, and before we turn to discussion, is there a motion to approve the recommendation of the East Cliff Property Task Force?
So moved.
Okay, there's a motion. Is there a second?
Second.
And there's a second. Okay, now we'll turn to discussion. Is there any discussion? Hearing no discussion, Mr. Langworthy, could you please call the roll?
On the motion to approve the recommendation of the East Cliff Property Task Force, Regent Davenport.
Yes.
Regent Davenport votes yes. Regent Farnsworth.
Yes.
Regent Farnsworth votes yes. Regent Gully is absent. Regent Ruth Johnson.
Yes.
Regent Ruth Johnson votes yes. Regent Tad Johnson.
Yes.
Regent Tad Johnson votes yes. Regent Kenyanya.
Yes.
Regent Kenyanya votes yes. Regent Mayron.
Yes.
Regent Mayron votes yes. Regent Talurabe.
Yes.
Regent Talurabe votes yes. Regent Turner.
Yes.
Regent Turner votes yes. Regent Verhalen.
Yes.
Regent Verhalen votes yes. Regent Wheeler.
Yes.
Regent Wheeler votes yes. Vice Chair Hipsch.
Yes.
Vice Chair Hipsch votes yes.
The motion is approved. So thank you for that. Thank you to Mary Davenport for chairing the task force. Okay, there being no additional business before the board, this meeting is now adjourned. So I think
In and out, 22 minutes.
Mary, what I read on that thing is only 4 out of our 5 campuses were in the injunction. So we had more Morris wasn't in the injunction.